Hello, everyone. Wearing a black shirt today. Got a beard from vacation. I look like a movie villain from a Western. So you should definitely trust me. Obviously, I'm the right person to ask about these questions. No idea why I'm wearing a black shirt. I'm Vincent White. I'm an employment attorney. I work in New York, and we're dealing with some changes recently signed in by Governor Cuomo to the New York State Human Rights Law, the law that deals with discrimination and sexual harassment in New York State. And most of these are great. They're great changes that help victims and plaintiffs and attorneys on the plaintiff side. Really a huge benefit to the community, a huge step in the right direction. The first of which is an end to the Faragher-Ellerth defense, which means nothing to you, obviously, because why would it? You don't work in this industry. But essentially, employers no longer get a shield if an employee fails to avail themselves of all the preventative measures internally at a company, which makes sense because if you're being victimized by someone in your company and that someone is, very important or, God forbid, a part of HR or your company doesn't have an HR, you're not going to want to subject yourself to that internal process. That's going to be pointless, and it's certainly going to feel completely futile. So many claimants don't do that. And I don't think skipping that process should give a shield to the company. I never did. It always seemed ridiculous to me. So I really do applaud this change. This is a step in the right direction, absolutely. Now the standard is being lowered for sexual harassment claims, and that's pretty incredible. Now, for years, the federal standard is severe and pervasive. And there's a huge amount of case law as to what is severe and pervasive, what's not. Now, in New York, we're going to be dealing in a world where anything more than a petty slight will be actionable. And that's incredible. Because you shouldn't have to go to work and, have a low-grade sexual harassment or a low-grade level of discrimination that pervades your life while you're earning a living, but just wasn't bad enough to rise to the level of severe and pervasive, so it wasn't actionable. That's not fair. You shouldn't have to live that way. So another great change. Really a big fan of what the legislature and the governor did here. Huge proponent of the changes so far. The New York State Division of Human Rights will now be able to hear cases for up to 3 years. Previously, they were held to only 1 year, and then after the 1 year mark, you'd have to bring your case in state court instead under the state human rights law, and you'd have to, decide if you want a jury and all of that. That was fine, except that going to state court is far more expensive than bringing a case in the State Division of Human Rights. So, often attorneys are unwilling to front that huge cost of going to state court litigation. Or, maybe a claimant doesn't want their name on a discoverable docket, on a public docket. So the State Division being extended for 3 years is now going to let plaintiffs keep their name off a public docket. It's going to give them also a cheaper option for 3 years instead of 1 year, which is incredible for them. I think it's a huge advantage. Now this next one is always been one of my pet peeves because there has been in our industry a trend towards mandatory arbitration agreements because employers don't want a lot of attention. They don't want a lot of publicity. They might not want the case going in front of a jury. Not ideal for them, right? So they have mandatory arbitration agreements. Those are now going to be not viable. You can't force someone into an arbitration agreement for any of the protected classes in New York, and that's going to be it's going to return a lot of the protections that employees in New York had previously before this move to mandatory arbitration happened. And I think that will really return the fear back into the hearts of employers where I think it should be, frankly. Even though I'm dressed like a villain, I still think employers are the bad guys. Not always. There's great employers, just, the employers who get it wrong. All right, non-disclosure agreements. And I think a lot of people are not going to agree with me about this one, but I think there's a lot done here And I think these changes are, in general, a complete mess. They don't really make a lot of sense. But let's touch on the higher points here. So now, non-disclosure agreements are no longer legal, except they are. So now, if you sign a non-disclosure agreement as part of your settlement, right? Like, let's say your employer comes to you and says, I'd love to give you $100,000 to settle this case, but I don't want you talking about it after we settle things. I want confidentiality. I want this to be kept quiet. Okay, you can do that. You can agree to that. You can't agree to that and say that you won't comply with a subpoena or an investigation, things like that. You still have to comply with all the laws of the land, but you can agree in general not to, practically go talk to a reporter about your case after you settle it and sign a, non-disclosure agreement. Here, you can actually still sign the non-disclosure agreement. It's just that there's a 21-day cooling off period, essentially, where you can think about whether or not you want to sign the non-disclosure agreement. Now, that's great, and that protection is now extended. It's not just sexual harassment anymore; it's all the protected classes. Great, I guess. I mean, usually people think long and hard about accepting a settlement agreement, and the terms of that settlement agreement are negotiated at length, and things like non-disclosure agreements are fought over for days and weeks and sometimes months before the settlement agreement is ever finalized and signed. So I don't necessarily know what the 21 days is for, except I guess it's for unrepresented plaintiffs, plaintiffs who don't have an attorney, pro se victims, things of that nature, people of that nature, because they don't, nobody's told them to slow down and think about whether they want to sign a disclosure agreement, right? So in that sense, it does help people, I suppose, but it does also create a lot of confusion. And in this set of changes, there's a number of other changes that get made, and we won't go into all of those. There's quite a bit there. So now there's also some new sexual harassment training guidelines. I'm pretty sure in 2019, every employee in New York State pretty much knows they shouldn't sexually harass their coworkers and has a pretty good idea of what sexual harassment is. Maybe that's optimistic on my behalf. I mean, maybe I'm not being realistic. I'm sure there's people who come from nations, where things are different and cultures where things are different. Maybe they don't know and they get here and they need a training. Maybe that's very real. But in general, I'm going to say that 99.9% of the population in the workforce know what they should and shouldn't do. They just, if they're bad people, might not care, right? So I'm always a little with training. I mean, does it make a difference? Does it really make the world a better place? But I guess that's prevention, right? You have to try to both prevent these things from happening, and then what we do is we punish people. If the training didn't prevent it, then we hunt it down and we punish you for it, right? So I guess it's not surprising that I think the prevention is a bit silly, but maybe I'm wrong. Maybe training has made the world a better place. Maybe it's made the world a safer and more respectful place. And if it makes one person more comfortable in the workplace and makes one person's life better, then okay, this is good then, and I'm wrong, right? So I shouldn't be so dismissive of this change, I suppose. Now this last part is incredible. It's really, I love what they did here. The changes urge a judge to a liberal construction when interpreting the New York State human rights law. And that's a funny way to say it, but basically, you've got a judge and they're looking at the law and they're trying to figure out, okay, this set of facts, this particular case that we're dealing with today, how would we apply the law to this situation? Not an easy job all the time, right? Crazy things come up. Interesting situations come up that no one in the world ever thought of when they were drafting the law. And judges are faced with these routinely, right? It's part of our industry. We see things and we say, oh, I didn't know that was a thing that could happen, right? And then judges have the unenviable task of saying, all right, no one's ever conceived of this situation ever in the history of the world. how do I deal with it? And how do I apply this law to a situation the law drafters never thought of? And essentially, the judge's goal under this change should be maximum deterrence of workplace discrimination. So when they're interpreting the law, the goal in their heart, what they should be doing, is saying, okay, what interpretation of this law is going to maximize workplace safety, right? What interpretation of this law is going to maximize the deterrence of workplace discrimination and sexual harassment? And that's beautiful. That is amazing guidance for judges. I think it makes the judges' lives easier. I think it makes odd fact patterns and odd questions of fact. It pushes them into the realm where now attorneys can help those people instead of saying, boy, I don't know if I can help you. I'm not sure, right? That always upsets me. To meet someone and to not be sure if I can help them is so disquieting, right? I can never guarantee someone a victory, but you can usually tell someone, yes, I think this is a potential claim, and I think we can try to help you here. What always really worries me is when you have to tell a client, listen, I've never seen something like this. I cannot say what a judge will make of it, and I'm worried what a judge will think and what a judge will decide. Here, with this interpretation, I don't think plaintiff side attorneys are going to be faced with that question anywhere near as often, and that makes me really happy. So, you know what? Usually not a big fan of the politicians, but my hat's off to you guys. Thank you.